Let us begin now with the first question and answer session. We will try to answer as many questions as possible. Therefore, we ask that only one question be asked per phone call, and that these questions be as brief as possible. You may call the studio directly at the phone numbers or fax which now appear on your screen. We remind you to make your phone calls at a distance from the monitor to avoid feedback. Let us continue. Now we have the first question has come in by fax from Fenalco, Medellin, Colombia. The question is for Dr. Mary Teagarden. Do some alliances have more conflicts than others?
Bienvenido, Medellin. Es una pregunta muy interesante. Yes, some alliances do have more conflict than others. Equity joint ventures, for example, require an ongoing relationship between the partners, and that escalates the amount of conflict and introduces a high failure rate for companies engaging in this form of alliance.
Okay, next we have a live question from the Instituto Universidad Empresa, Universidad Blas Pascal, Buenos Aires, Argentina. Okay. Let me repeat the question. This is a question for Dr. Teagarden. What are professional maps?
Bienvenido, Argentina. Professional maps are scripts that we carry in our head. They're training that we've had. They're all of the background that represents our profession, and it conditions the way we think about the world.
We now have a second fax that has come in from KTV Communications, Rio de Janeiro, Brazil. Dr. Teagarden, which strategies for dealing with conflict are most used by businesses, such as bargaining or fighting?
Businesses are still stuck in the traditional modes of conflict resolution, and you see much more bargaining and fighting or competition going on between partners trying to create a win-lose situation rather than a more creative win-win situation.
Okay, we now have a live question from la Universidad Nacional Autónoma de México, Facultad de Medicina, Veterinaria y Zootécnica en México, Distrito Federal.
Muy bien.
Saludos al panel.
Good morning. Greetings to the panelists. My question is, what can a company do when they're faced with unilateral sanctions taken by a very powerful country with whom we are sharing a trade agreement? And, for instance, what can we do when we find a situation where there is a blockade against a weaker country, and you are a partner in this trade agreement where the powerful country is blockading another country with which you feel you have things in common?
Dr. Teagarden, did you hear the question?
I did hear that question. It's a very complex and difficult question to respond to. Essentially, from a theoretical perspective, the weaker country partner needs to try to enhance their importance in the trade relationship. And by enhancing their importance, that should help smooth the conflict between the parties.
Mr. Holbein, did you hear the question?
Yes, I did.
What's your comment on that?
Well, there are specific mechanisms that are available for governments to discuss issues such as you have raised. In particular, in the new World Trade Organization, there are rules as to how each government is to conduct its international trade relationships. There is a new framework that has been established governing the trade throughout the multilateral system, to the extent that either consultation among governments about the particular blockade or other type of issue you're discussing, or a further mechanism of actually raising it with other members within that broader organization, or certainly within the NAFTA framework if it's Mexico, the United States, and Canada. There are mechanisms established to provide ways of resolving that and ways of discussing those kinds of issues to bring it to the forefront. It's necessary and important for the business community to let their government know, let those contact persons within the government know what the problem they're confronting, what, specifically what their problem is, so that the government officials can then deal with it and assist that industry specifically on that issue.
Very good. We now have a live question from the Instituto Universidad Empresa, Universidad Blas Pascal, Córdoba, Argentina.
Bien, buenas tardes.
Good afternoon. The name of, on behalf of the Universidad Blas Pascal, we would like to thank this opportunity of participating in this linkage that has been organized by such a prestigious educational institution, San Diego State University. Our question follows. Do you think that giving more importance or more room for mediation would be beneficial for the future of the trade agreements such as NAFTA, for instance, or for Mercosur, talking about the Southern Cone here in Latin America?
Let me direct that question first to Mr. Holbein. Did you hear the question?
I did, thank you.
Okay.
I believe that mediation and other alternative dispute resolution techniques do have a role within any of these international trade agreements. On the broad front, government to government, it is important to have ADR techniques for the governments to discuss and resolve issues at the very, at the lowest level possible to keep trade moving and make it easier for the business community and all countries involved to conduct business as smoothly and efficiently as possible. In addition, I think mediation techniques are important private company to private company, and those need to be developed within the broader context of the framework provided by these trade agreements, whether it be Mercosur or NAFTA or WTO, any other organization.
Our next question is a live question from La Federación Nacional de Comerciantes, Santa Fe, de Bogotá, Colombia.
Buenos días. ¿Cuáles son los nuevos
What are the new mechanisms for international negotiation that we can apply in Colombia, for instance?
Gracias.
Thank you.
Dr. Teagarden?
The mechanisms that I certainly advocate are mechanisms that are based on collaboration and sharing, creating joint resolution to problems, as opposed to adversarial or confrontational resolutions to problems. Things such as we call them, creating win-win situations.
Our next question is from the Instituto Tecnológico de Celaya, Celaya, Guanajuato, México.
Bueno, gracias. Buenos días.
Good morning. This is Engineer Rivera from Celaya, Guanajuato. I would like to ask you, what are the items of the NAFTA that has been given rise to more conflicts within our country and between our country and the United States? Which one would you say?
I'm going to direct that question to Mr. Holbein.
Okay, thank you. There have been a number of areas that have caused various types of problems under NAFTA. One set of problems was more mechanistic or technical in nature, and particularly in the early days of NAFTA, I think there were a lot of customs and border problems. Those, to my knowledge, have all been pretty well resolved, and trade is flowing very smoothly. In our dispute settlement mechanism that I'll be discussing in my presentation, the subjects tend to be large industries such as the cement industry in Mexico, the steel industry in the United States, the steel industry as well in Canada, have been the source of some dumping and countervailing duty disputes. In the more generic area governed by Chapter 20, we find that agricultural and fisheries products tend to be the issues that come to the forefront. But there are many other areas, and many areas within the agreement, both technical and substantive, that can come up, and the mechanisms are there for resolution at very quietly within the context of government consultation or private discussions. So I think there's a lot of mechanisms, and pinpointing one area might be a little bit too specific.
Very good. Our next question is from the Instituto Universidad Empresa, Universidad Blas Pascal, Buenos Aires, Argentina.
Buenas tardes, mucho gusto.
Good afternoon.
Yo soy el doctor Jorge Luis Santana,
I'm Dr. Santana,
presidente del Comité
and I
Internacional de
preside
Derecho
over the International Committee for Arbitration Law of the Inter-American Bar Association. I would like to thank the University, Blas Pascal University, for this opportunity to ask this question, and this I consider a very important event, a teleconferencing event. I would like to say to you that I have very carefully studied the NAFTA agreement, and I have arrived at the conclusion that it is much too long, that it has absolutely no relation with the international arbitration mechanisms, and it is very difficult for individuals to get to arbitration, whereas for governments this is something simpler and easier. And that's the conclusion we arrived at when we participated at the 12th meeting organized by the University of San Antonio in Texas. I believe that NAFTA deserved, through arbitration, other kinds of solutions, and we must apply the model law by the United Nations Committee for International Commercial or Mercantile Law. I ask you, are you happy with the solutions that NAFTA presents for resolving conflicts, international conflicts, and particularly, have you been satisfied so far, or particularly, are Mexicans satisfied as far as the integration of the arbitration juries or tribunals? Thank you.
Mr. Holbein?
Thank you. It's an excellent question. There is a mechanism within the NAFTA, in particular Article 2022 and also in Chapter 7. There are working groups established for private commercial disputes and another one on private commercial disputes involving agricultural goods. These working groups are striving to begin to lay the framework for a broadening and an improvement in the business relationships for private companies that are taking advantage of the opportunities provided for this treaty or by this agreement. And as the FTAA process, the Free Trade Area of the Americas process, begins to unfold going to the year 2005, I believe that these working groups can contribute significantly to an improvement in the environment for private commercial disputes under the agreements. You must understand that the agreements are to establish the broad framework for the governments to conduct business in a more liberal trading environment, and it is not, every item is not specifically targeted for private companies, but I think that it can be improved upon and will be improved upon as we move forward into broadening NAFTA through the next decade.
Before we take the next question, let me just add one note. One of the programs which will be coming up next will feature the president of the American Arbitration Association, who will talk about the international efforts that have been made by that organization, sometimes known as the AAA or La AAA, in the international realm. He will talk at length about arbitration and about mediation, about the application of UNCITRAL, of the international rules, of the AAA, and also of the ICC or la CCI. So that is a question which we will return to, I believe, in the second program, maybe again in the third. The next question that we have is a live question. It is from La Universidad Privada Boliviana in Cochabamba, Bolivia.
Adelante, por favor.
Sí.
interferencia.
Creo que cuando se habla
I
de
think that when you talk
brechas
about
o diferencias
gaps
culturales,
or cultural differences between two countries, it is necessary for us to emphasize that fact that we cannot generalize over on a culture, a nationalist culture of a country to ensure the success of a certain negotiation. I think that what really impacts a negotiation is the culture and the values that you are living in each one of the cultures in each one of the organizations. What do you think about this?
Dr. Teagarden, would you like to comment on that?
Yes, that's a very good question. If you think about culture, you can think about it like an onion with many, many layers. When we start to talk, we talk about the outside layer, which is most generalized. We talk about the Bolivian culture, the Venezuelan culture, the American culture. But the organization culture is the next level down, and there is incredible difference between organization culture of a company in Bolivia and organization culture of a company in the United States. And those organization cultures also influence the outcome of the negotiation. And at the next level down, you can think of the professional maps or the professional cultures that we bring. Those also influence the outcome. For example, an engineer negotiating with a marketer see the world very differently. So it's very, very complex. One layer, the next layer, the next layer. Thank you for your question.
The next question is live from KTV Comunicaciones LTDA, Rio de Janeiro, in Brazil.
Por favor, yo soy Antonio Carlos y estoy hablando desde Rio de Janeiro, Brasil.
Saludos, greetings from Rio de Janeiro, Brazil. What are the tactics, the strategies to resolve conflicts that are most used today by multinational companies?
Dr. Teagarden?
Unfortunately, multinational companies are starting to use collaborative techniques, but their preferred techniques are much more adversarial. We see much more use of formalized contracts and litigation back to the contracts as ways of resolving dispute. It's not the best way to do it, but it reflects the current reality, something that we're trying to change with this kind of educational framework.
Our next question is a live question from the Instituto Nacional de Investigación y Capacitación de Telecomunicaciones en Lima, Perú.
Good morning. Our question is, up until when should you continue to negotiate? Or when is it wise to break a negotiation and just stop negotiating?
Dr. Teagarden?
Yet another very good question. Before you enter a negotiation, it's critical for the parties to, in their own mind, be very clear about the outcomes that they need from the negotiation. If you are in a negotiation and it's going in a direction that is not meeting your needs, that may be a time to terminate the relationship. If you see that it does not appear to be possible, but more importantly, that's a time where you may be able to call in mediators to help bring the parties together. But it starts with a definition before you ever begin negotiation about the outcome that you need to achieve for yourself. We call that a backup point at which you're willing to walk away from the negotiation. Thank you.
Very good. Our next question is live from Wright State University in Dayton, Ohio.
Hi, good afternoon. Greetings from Dayton, Ohio. The question is, with the increasing presence of international trade, what is the likelihood that there will be a universal way of conflict resolution between countries? And if you propose that there is a future for this, what do you feel the structure would be?
Let me direct that question to Mr. Holbein.
Thank you. The current mechanisms, if you'll, it is now a new agreement has come into place through the World Trade Organization that is establishing a framework for governments to discuss multilateral trade issues and individual trade issues. based on a framework of rules at the global level. This mechanism is being expanded at a very rapid rate to include almost all the countries in the world. Not all are involved in the WTO, but most, if not all, of the countries in Latin America certainly are involved. And that is a mechanism that is very important for countries to discuss issues. At the individual company level, I think that there is a lag that perhaps is coming, but there are certainly arbitration mechanisms and ADR mechanisms that are established globally through the ICC, the AAA, and other organizations that can also assist at the micro level, if you will, rather than at the macro governmental level. I think these are all very important, and it is an evolving process. Thank you.
Very good. Our next question is live. It is from the Universidad Tecnológica de Panamá in Panamá, Panamá.
Aló, muy buenos días.
Good morning. We would like to ask the following. Do you have any kind of statistical record about the average time that takes to resolve a conflict using a formal process or versus an informal process? Thank you.
No idea.
Dr. Teagarden or Mr. Holbein, do you know of any such registry?
I certainly have not seen data to that effect, and really it would very much be a function of the complexity of the conflict, the nature of the conflict. But I have not seen any data at all.
Mr. Holbein?
Well, I do have some data that is available for the specific mechanisms that we use under the North American Free Trade Agreement and its predecessor, the U.S.-Canada Free Trade Agreement. Certainly in the private area involving dumping and countervailing duty matters, normally panel reviews of those matters take 315 days for a final decision, but they can be lengthened considerably if there is if the matter is sent back to the agency that made the decision for further action. I think the average on our cases is running about a year to a year and a half for most of our matters to be resolved. This is considerably shorter time period than has been the case for our national court system. And in fact, the speed and efficiency of dispute resolution has been one of the strongest selling points, particularly of this Chapter 19 process of NAFTA.
Let me add just one comment. I believe that we will have later in our programs representatives of groups, as I mentioned, such as the American Arbitration Association. In the commercial context in which I practice as a lawyer, I would say that it takes probably 6 to 9 months to resolve a business arbitration from the filing of the demanda or the demand to the end of the hearing or audiencia. That's not for governments, that's between private individuals. Our next question is coming from the Instituto Politécnico Nacional, CITEDI, de Tijuana, Baja California, México.
Bueno.
Adelante.
Bueno. Habla del contador público Francisco Palomino.
I'm a CPA.
Del Centro de
Francisco Palomino is my name, and I am from Digital Technology Development and Research Center. And taking this organization as an example, the CEE, the European Union, taking that as an example, what possibilities do we have that here in our continent we would have a free flow of goods and persons, and as it is happening in the European Union nowadays? What chances do you see that this could happen in our continent?
Let me address that first to Dr. Teagarden, and then Mr. Holbein, if you would like to add something.
Comparing the situation with the European Union, I think that we are focusing primarily on trade with the agreement that we have with Mexico. I think that the free flow of people is a logical, natural extension of this, and I think de facto in the future we will see more of a flow of people, particularly professionals. But that's supposition on my part.
There is a big difference between the framework that's established under the European Union and that under NAFTA, and that is that the European Union is seeking to form a literal political, social, economic union of all of the nations, whereas the goal of the free trade area within the Americas, or the goal of NAFTA, has been to primarily speak to the economic conditions in international trade and to reduce barriers and improve the business climate. There are, however, provisions made for temporary entry of business persons, and certainly the various rules in such areas as services, trade in goods, etc., are very important considerations that affect the flow of people and doing business in any of the countries involved in those agreements.
Our next question is live from la Universidad Tecnológica de Tula, Tepeji, en Tula de Allende, Hidalgo, México.
This is regarding the strategic alliances between North American investors and Latin American investors. In what country do you see them having more success? Where in your experience, where have they been more successful?
Dr. Teagarden?
In my experience, it's not so much a function of country-to-country relationships, but basically when you see asymmetry in level of economic development, asymmetry in size of the companies partnering, or asymmetry in level of technology involved in the joint venture, you see more failure. And when there is more symmetry, when they're more in balance, those are the more successful alliances.
Our next question is live from la Universidad Autónoma de Baja California Sur, La Paz, Baja California Sur, México.
Sí, gracias.
Thank you.
La pregunta es,
Question is, are there any studies, systematic studies, regarding the cultural differences in international businesses, enterprises, and what are those studies?
Dr. Teagarden?
Yes, there are extensive studies that focus on international cultural differences. Some of those are cited in your handbook that you have that support this session. And if you look in your bibliography, I have also cited quite a few studies that focus on cultural differences. Mostly they focus on pieces of the business or processes like negotiation. But I have identified some of those for you in the support material. Very good question.
Our next question is again from Wright State University in Dayton, Ohio, in the United States.
Hi, hello again from Dayton, Ohio. Hola, buenos días. Can I make my question in Spanish? Okay, then in Spanish. Me gustaría saber si hay
I would like
algún
to know
tipo de
if there
cultura
is
que
some kind of culture that produces more conflict, and if that's the case, what is it due to?
We need that question repeated.
Can you repeat the question? I think they hung up.
Is there some culture that produces more conflict than other cultures?
Okay, let's answer this question. We think we heard that it was whether there is one culture that produces more conflict than others. Dr. Teagarden, do you have a comment on that?
I can talk generally about cultures. In cultures where adversarial relationships are the norm or the preferred way of solving problems, you see much higher levels of conflict than in cultures that are more willing to collaborate in resolving problems.
Let us continue with Module 2, in which Mr. Holbein will explain the mechanics of some of the institutional mechanisms for international conflict.
I'm delighted to be able to participate in this first program in the International Training Center's series on international conflict management. Today I want to describe to you the institutional dispute resolution mechanisms provided for in the North American Free Trade Agreement. I will refer to that agreement as the NAFTA throughout my presentation. I will describe the various organizations created under the NAFTA, including their functions and how they operate. Most of my talk will focus on the binational panel processes provided for by the NAFTA to handle general disputes between the governments and also to resolve private disputes concerning anti-dumping and countervailing duty decisions made by the NAFTA governments. The North American Free Trade Agreement, built on the foundation created by the U.S.-Canada Free Trade Agreement. I will refer to that agreement as the FTA. NAFTA created the most comprehensive regional free trade agreement ever negotiated, affecting 380 million people and producing nearly $8 trillion worth of goods and services. It resulted in removal of trade barriers, reductions in tariffs, and a substantial increase in trade among Mexico, Canada, and the United States. It has also helped during Mexico's financial crisis to maintain the trade and financial liberalization measures they have undertaken, despite pressures to back away from those commitments. Let me now turn to the institutional aspects of the NAFTA. The highest level policy organization created by the NAFTA is the Free Trade Commission. The Commission is led by the U.S. Trade Representative, Canada's Minister of Trade, and Mexico's Secretary of Trade and Industrial Development. They are required to meet at least once per year in regular session. The Free Trade Commission has served several major functions as follows. They supervise the implementation of the agreement. It oversees its development. It supervises the committees and working groups established under the agreement. It resolves disputes regarding interpretation or application of the agreement. And it considers any other matters affecting the operation of the agreement. To assist in this broad mandate, the Commission may establish and delegate responsibilities to ad hoc or standing committees or working groups or groups of experts. The Commission may also seek the advice of non-governmental persons or groups and take such other actions as the members agree. To assist the Commission in its responsibilities, Annex 2001.2 of the agreement creates several committees responsible for monitoring and reporting on the implementation of the NAFTA. These committees report to the Commission on such issues as trade in goods, agricultural issues, sanitary and phytosanitary measures, standards, government procurement for small businesses, and also financial services. The chairs of these committees are senior government officials, and the participants will be the appropriate officials from each government. The Annex also creates two advisory committees, one on private commercial disputes and another on private commercial disputes regarding agricultural goods. They comprise persons with expertise or experience in these fields. In addition, several working groups are working to further develop the agreement in some important areas such as rules of origin, agricultural subsidies, competition law, and temporary entry. The Commission has also established working groups on emergency action, government procurement, services and investment, subsidies and countervailing duty, and dumping and anti-dumping duties. I'd like to describe a bit of information that will be helpful for the private sector. The NAFTA office at the U.S. Department of Commerce has developed a NAFTA fax information service that can be reached on